In a quiet suburban neighborhood, a marriage falls apart. Mr. Daniel and Mrs. Ira, once partners in life, now stand divided. When Mr. Daniel leaves the family home to live with another woman, Tasha.
So this is it. After everything,
Let's not make it harder than it is. I've moved on.
so what about our house?
Fine. You can take it. If you pay the 100,000 ringgit mortgage, then I'll transfer my share to you.
You promise?
Yeah, sure. We'll write it down.
A final agreement is made, one that will soon be tested in court. A written promise is made, and Mrs. Ira, trusting those words, sacrifices her savings.
The primary legal issue involved is whether there was a valid intention to create legal relations between Mr. Daniel and Mrs. Ira. In contract law, the court must determine whether the agreement was meant to be legally binding or merely a social or domestic agreement that the law should not enforce.
This was so funny. I paid everything. The mortgage is cleared. So you can transfer the title like you promised.
Wait. That was just between us. A family matter, not a legally binding.
But you gave me your word.
My words doesn't make it a contract.
Oh my god.
Now, let's apply the elements of a valid contract to the agreement between Mr. Daniel and Mrs. Ira. Mr. Daniel made a clear offer. He would transfer his share of the house to Mrs. Ira if she pays the remaining mortgage. Mrs. Ira accepted the offer by paying 100,000 ringgit of mortgage. There is an exchange of value. The house for the 100,000 ringgit mortgage payment. This satisfies the requirement for consideration under Section 26 of Contracts Act 1950. While family agreements are usually non-binding in the case of Balfour versus Balfour, the presumption can be rebutted in the case of married versus married. The written and signed agreement between Mr. Daniel and Mrs. Ira shows that they intended to create legal relations. The subject matter, the house, and the price, the mortgage payment, are certain under Section 30 of Contracts Act 1950. Both parties are competent adults under Section 11 of Contracts Act 1950. Was the contract merely emotional or legally enforceable?
This is the case of Mr. Daniel versus Miss Ira regarding an alleged breach of agreement involving a property transfer. Miss Yana, you may start.
Your Honor, this is a clear case of binding agreement. There was offer, acceptance, and consideration. Mrs. Ira paid 100,000 based on Mr. Daniel's promise.
And the agreement was written?
Yes, Your Honor, signed by both parties.
I trust you.
Your Honor, it is not a commercial contract. It is domestic arrangement between spouses. Such agreements are not intended to be legally binding. Even when written? Yes, Your Honor, the intention meant this. This was an emotional understanding, not a legal one.
Your Honor, may I call plaintiff to the stand?
Yes, you may proceed. Plaintiff, you may go now to the stand.
Mrs. Ira, why did you pay the 100,000 ringgit?
Because he promised the house would be mine.
So did you rely on the promise?
Completely.
That's all, Your Honor.
Mr. Daniel, did you intend to create a legal contract?
No, it was just to settle things peacefully.
That's all, Your Honor.
Your Honor, I would like to cross-examine the defendant.
Proceed, counsel.
Mr. Daniel, why did you put it in writing?
Just what arguments?
Oh, or you just want to make this situation serious, so Mrs. Ira need to pay the mortgage. Your Honor, please allow me to call out the witness. Mr. Shah, were you aware of this agreement?
Yes, he told me about it.
What did he say after she paid?
He said once she finished paying, the house will still be his.
Miss Ira, did you aware of this agreement?
Yes, we signed a contract.
What did he say afterward?
He said when I paid the mortgage, he will give me the house.
This is not merely a family matter. This is a promise supported by action and sacrifices. If it is not enforceable, justice fails those who act in a good faith.
The law must draw a line. Not every personal promises becomes a legal obligation.
The possible legal outcome. First, binding contract. The court will likely rule that a valid contract exists because the written agreement proves legal intent. Second, specific performance. Under Section 11 of the Specific Relief Act 1950, the court may order specific performance. This requires Mr. Daniel to perform his specific obligation, transferring the house title rather than just paying damage. The last one is injunction. The court might also grant a perpetual injunction under Section 50 of the Specific Relief Act to prevent Mr. Daniel from trying to sell his share of the house to any other party.
The court finds the agreement was signed and written. Ms. Ira performed her obligation fully. There were clear reliance and financial sacrifice. The presumption against domestic agreement is rebutted. This is not a casual agreement, it is a legally binding agreement. Mr. Daniel is ordered to transfer his share of the property to Ms. Ira. That is the decision of court. Court is adjourned.
In the end, the law protects not just written words, but trust, fairness, and reliance. A promise, when acted upon, carries weight. And sometimes justice restores what betrayal tried to take away.
Cantik macam ni, buat dekat tu mana?